save the United States, the state of Tennessee, and this honorable court. Please be seated.
Thank you, Madam Clerk. Good morning, everyone. This is the second day of the January session of the Tennessee Court of Criminal Appeals here in Nashville. I'll introduce the panel and we'll move quickly on to our cases here. My name's Robert Wiedemeyer. I live here in Nashville. To my right, Judge Robert L. Holloway Jr. from Columbia, Tennessee. To my left, Judge Timothy L. Easter from Williamson County, Tennessee. And the whole section is from all the judges are from the middle section today. Each side has 20 minutes to argue their appeal. If you represent the appellant, yesterday the state was in that position twice, I think, and you want to reserve rebuttal time, please do so before you begin your argument. That way our clerk can help keep up with your time there with the light system, and I'll try to help you keep up also. We have read the briefs for both sides, and we'll be assigned the cases later, and at that time we'll have the full access to the records, but we do know what you've said in your briefs, so you can factor that in when you make your arguments today. Are there any preliminary matters, Madam Clerk?
No, Your Honor.
All right then, call the first case, please.
State of Tennessee versus Bianca Renee Bankston.
Good morning.
Good morning, Your Honors, and may it please the Court, William Gill from the Appellate Division of the Public Defender's Office. I'm here this morning on behalf of the appellant, Ms. Bianca Bankston. With the Court's permission, I will reserve 4 minutes for rebuttal.
Certainly.
The issues in this appeal relate to the length and manner of service of the maximum sentence that Ms. Bankston received after she pled guilty to aggravated vehicular assault in this case. Based upon these issues, we ask that the Court reverse the judgment of the trial court and either remand for resentencing or order that she serve the remainder of her sentence on probation. With regard to the length of Ms. Bankston's sentence, as this Court knows, errors as to enhancement and mitigating factors, although they do not necessarily constitute reversible error, they may do so when the outcome is a sentence that fails to comport with the purposes and principles of sentencing, and that includes the principle that the sentence should be the least severe measure necessary to achieve the purpose for which the sentence was imposed. In this case, we contend that the trial court erred as to several enhancement and mitigating factors. That includes enhancement factor number 6, which applies when the personal injuries inflicted upon the victim were particularly great. Of course, no one disputes that the victim in this case suffered extremely serious injuries. Ms. Bankston acknowledged that at the sentencing hearing when she apologized, took full responsibility for her actions, and acknowledged the seriousness of those injuries. So this is not a factual question, this is a legal issue, which is that this Court has held that enhancement factor 6 may not be applied to this offense, because one of the elements of the offense is serious bodily injury. As a result, it is inherent in the crime that the victim suffered these types of injuries. Now, the trial court and the state seek to justify the application of this factor because the victim in this case, Mr. Pugh, suffered psychological injuries. The problem with that argument, we respectfully disagree with that argument, because this Court has held on several occasions that psychological injuries can constitute serious bodily injury. Indeed, the statutory definition of serious bodily injury specifies that it may be an injury to an organ, and the human brain is in fact an organ, a rather important one, or to a mental faculty. And psychological injuries may interfere with one's mental faculties. Indeed, that was the case here, as you can see from Mr. Pugh's testimony. And so we contend that enhancement factor 6 legally cannot apply because great injuries are already baked into the offense in this case. We also contend that the trial court erred by declining to recognize any of the mitigating evidence in this case. Ms. Bankston properly raised 2 mitigating factors. That includes mitigating factor number 11, which applies when the offense was committed under circumstances that indicate that there was no sustained intent to violate the law. That is the case because Ms. Bankston committed the offense in this case in a moment of panic. Moreover,
How was she panicked when she backed her Hummer up over the mulch bed and ran over this guy's body?
she testified, and I believe this evidence was undisputed, that although she did not remember everything about the incident, that she remembered that she became really scared in this moment. She was involved in a verbal interaction with Mr. Pugh and other individuals that were in that parking lot, and she became very concerned, very panicked, because she thought she was going to get in trouble and lose her job. And so she just testified that she remembered entering a moment of panic at that moment.
Is that because she was intoxicated on the job?
That very well could have been the case, Your Honor, and Ms. Bankston did acknowledge that she was intoxicated at that time, and she admitted to her blood alcohol content. So those matters are really not disputed. And it would have been a different case, frankly, Your Honor, if the trial court had made a finding that her testimony was not credible, but the trial court did not make any such finding.
What testimony did she give?
She testified that she did not remember much about the incident, but that she remembers being in a panic because of the verbal altercation.
Was that testimony subjected to cross-examination?
Yes, Your Honor.
That wasn't part of the allocution?
Correct, Your Honor. She testified to that at not only the plea submission hearing, but also at sentencing.
So she took the stand and testified at sentencing?
She did, Your Honor, and she...
I misunderstood. I thought she just made an allocution.
No, Your Honor, both occurred. At sentencing, the focus of her testimony was her remorse and her acceptance of responsibility.
Mm-hmm.
But if I'm not mistaken, she also indicated at that time that although she did not remember everything about this event for the reasons that Judge Holloway alluded to, that she did not dispute that it happened.
So she didn't dispute that her blood alcohol level was 3 times the legal limit?
She did not, Your Honor. She admitted to that. She accepted responsibility for that.
And also, going back to the enhancement that the trial judge imposed, let's just say you're correct, for sake of argument, on number
Certainly.
6. He found 2 others, and you don't dispute those at all.
That's correct, Your Honor. I believe he, in fact, it's not really in my interest to correct this, but 4 enhancement factors were applied.
Oh, okay.
And
right,
so
fine.
our
And-
argument is that one of those enhancement factors was an error, and then both of the mitigating factors that she raised.
The sentence was within range.
Correct, Your Honor. It was at the maximum within range sentence.
There are at least 3 enhancing factors that apply.
That is correct, Your Honor. However, because there was another enhancement factor that was misapplied, as well as 2 substantial mitigating factors, and one of those is mitigating factor number 13, which is the catch-all factor. The evidence did establish several well-established reasons for that factor to apply. Those included Ms. Bankston's significant family contributions, her work ethic, the fact that she had a sustained period of stability during the 10 years prior to the relapse that led to the events of this case. All of those things were brought forth during her testimony at sentencing and in the proof. And again, our contention is that the trial court did not make any relevant findings to dismiss these reasons for applying those mitigating factors. Instead, the trial court's findings were conclusory in that regard and did not specifically address them. Finally, Your Honors, the trial court did not appropriately consider the strong R risk and needs assessment. This has been litigated in a few separate panels before, a few separate cases by different panels of this court. As this court acknowledged in State versus Ross, in 3 separate provisions, the sentencing code uses mandatory language to indicate that the trial court must consider the strong R assessment. In this case, the assessment indicated that Ms. Bankston was at low risk for reoffending as long as she received appropriate mental health care. There was a strong R assessment filed as an addendum to the pre-sentence report. However, it was not included in the version of the pre-sentence report that was admitted as an exhibit at the sentencing hearing, and so it does not appear that it was before the trial court when it made the findings that it made when it imposed the sentence. As a one final matter, the state and I appear to agree that there are some clerical corrections that need to be made to the judgments in this case. I thank my friend for pointing those out in the brief. Specifically, there were 3 counts of vehicular assault. She pled guilty to one of those counts, amended to be aggravated. The other 2 should be reflected as nollie prost, and then all of the DUI counts should have merged into that count 4 that she pled guilty to. Again, the state and I agree on that, and it's laid out in detail in the state's brief. For these reasons, we ask that the court, if there are no further questions, we ask that the court reverse the judgment of the trial court and either remand for further proceedings or order that Ms. Bankston serve the remainder of her sentence on probation. Thank you.
Thank you. Counselor? Morning. This
Morning, Your Honors.
General Neff, is that right?
That's right.
All right.
Good morning, Your Honors, and may it please the court. Katie Neff on behalf of the state. Your Honors, this court should affirm the sentence of the trial court because the record overwhelmingly supports the imposition of the maximum sentence of confinement. I want to start by talking a little bit about the facts of this case, including the many injuries suffered by the victim, Mr. Pugh, whom I understand is watching this hearing on streaming. And then I want to take and address each of the defendant's arguments in turn. Ms. Bankston was a certified nurse assistant, and she was scheduled to work or called in to work at a Franklin assisted living facility on the date of the crime. However, Ms. Bankston had been heavily drinking. Her blood alcohol content, as the court noted, was actually above a 0.25%. She also had cocaine in her system, so she was using cocaine. And she was suspended from driving. Her driver's license was suspended for failure to comply with the requirement that she install a breathalyzer. None of that stopped her from driving her 3.5-ton Hummer from Nashville all the way to Franklin, where she was so intoxicated, she crashed into a van in that parking lot. Mr. Pugh, the facility director, was leaving for the day when he noticed the crash, and he and several of the other employees approached Ms. Bankston at her vehicle to discuss the matter. They noticed that she was heavily impaired, and they urged her not to drive. "I don't like how you're coming at me," she said to them, and she continued to back up her car with intent to leave. Mr. Pugh got out of the way, got onto a raised mulch bed that has a concrete barrier. She had a full open path to drive away without hurting anybody, but instead, she backed her car out, stopped, pulled forward a little bit, stopped, turned her wheel more to the right toward Mr. Pugh, locked eyes with him, and then drove her 3.5-ton Hummer into him, knocking him to the ground and running him over with both axles. Mr. Pugh's physical injuries were immense. But today we're talking about the psychological injuries because that's what's at issue in Factor 6. Mr. Pugh remembered, even years later after the incident, he remembered the sound of his bones cracking like splitting wood. He remembers the smell being under that car, the Hummer, and the smell as if it was in a garage. He remembered looking and seeing the back tire coming toward his head and believing he was going to die. And yes, he suffered many, many nightmares as a result of this, trouble sleeping, multiple mental health diagnoses, and a hospitalization for a psychiatric hospitalization, which he and his wife both discussed at length. There is no good argument that that psychological injury does not count for personal injury under application as to factor 6, and this court has repeatedly found so. Now, turning to the defendant's arguments as to mitigating factors. Let's start with mitigating factor 11, that the circumstances were unusual such that she did not have a sustained intent to violate the law, but the record would suggest otherwise. She began by violating the law, both with using cocaine, driving on a suspended license, driving under the influence of alcohol, all before she struck Mr. Pugh. She leaving the scene of a crash, a collision that caused property damage, and then again followed up with driving under the influence after. Now, her intent to commit crime was sustained throughout that morning, both before and after she nearly took Mr. Pugh's life. Also, I would challenge counsel, I don't remember the word panic being part of her statement. Going back through the record as I did, her statement when she discussed what was going through her mind, and yes, she did claim that she did not remember much of hitting Mr. Pugh, but she did admit, and this is close to her words, I thought I was going to lose my job. I thought, oh my gosh, I have to get out of here. Something to that effect. She was clearly trying to cover up her earlier crimes, and that's a common tale for criminality. This is a continued, sustained intent to commit crimes. As to factor 13, the trial court was well within its discretion to refuse to apply that factor. Let's look first, work ethic. The defendant wants you to mitigate her sentence based on her work ethic, but she was a certified nurse assistant who showed up to work with 0.25 blood alcohol content and cocaine in her system. The trial court was within its discretion to refuse to mitigate her sentence based on her work ethic. Her social history. The trial court, when examining this factor, expressly acknowledged that the defendant had a difficult life. But as part of that social history, it cuts both ways. She was educated, she had a good job, and she knew better. And the trial court was within its discretion to refuse to mitigate her sentence based on her social history. And then quickly, as to the validated risk and needs assessment, this court made clear that it considered the court record, it considered the pre-sentence report, and the validated risk and needs assessment is an essential part of the pre-sentence report. There is no pre-sentence report without the validated risk and needs assessment. So when the trial court states that it considered the pre-sentence report, that necessarily includes the validated risk and needs assessment. And just to be clear, in case there's any confusion, the validated risk and needs assessment was filed the very day after, as part of the court file, filed the very day after the original, the partial pre-sentence report was filed. So they're right next to each other, and the trial court had that validated risk and needs assessment more than a year before the sentencing here. So it is clear that the trial court considered the validated risk and needs assessment. It's clear that the trial court properly applied mitigating and enhancement factors. And as Judge Easter discussed, there are 3 enhancement factors that the defendant does not even contest. That she had a long criminal history in addition to that which was required for her range, that she violated the terms of her conditions, she violated the terms of her supervised release, and that she had no hesitation at committing a crime when the risk to human life was high. And so because the trial court's order is in line with the purposes and principles of sentencing, it's presumed reasonable, and this court should affirm. Thank you.
Thank you, General. Rebuttal argument?
Thank you, Your Honor. I'll just touch briefly upon one point that was raised during my friend's argument, and that is the matter of the enhancement factor. I do think whatever comes out of this case, this is something that could use some clarification in Tennessee law. The state has cited, I believe, one case, State versus Messick, which applies this enhancement factor based upon a psychological injury that occurred in addition to the physical injuries. Again, that's an unpublished case. The weight of authority, including the only binding published authority, holds that psychological injuries may constitute serious bodily injury. And so the implication of the state's argument is that psychological injuries are separate and cannot establish serious bodily injury. So the reason that's somewhat interesting is because if what the state says is true, then in a different case, when they are relying upon psychological injury to establish serious bodily injury, that element would be lacking. So there are two sides to this coin. And so again, we contend that the weight of the authority and the only binding authority establishes that psychological injuries are part of serious bodily injury. That means that they are inherent in the offense and cannot be used to enhance the sentence as took place in this case. Unless the court has any further questions on that, I will cede the remainder of my time. Again, we ask that this court reverse and either remand for resentencing or order that Ms. Bankston serve the remainder of her sentence on probation. Thank you.
All right, thank you, Mr. Gill. Both briefs were well-written and the case was well-argued. We appreciate it. We'll take it under advisement. Next case, please.
State of Tennessee